Thank you very much, Madam President. Madam President, I stand today here with pride to support the Honourable Minister in the Ministry of Finance in his maiden pilot before this House of the Bills of Exchange Amendment Bill 2022. I will not trouble this House with recapping much of what has already been said, so that what I am about to say will seek more than anything else to be by way of emphasis in respect of a number of things that have been said. But there are certain things that I would wish to dwell on in addressing certain concerns and in emphasizing certain matters. We know that the bill dates back, the original legislation dates back to 1884. I don't need to repeat that. The point there simply is that in the year 2022, we have to accept that we are moving into a reality of digital transformation in many respects, and therefore this bill is seeking to provide for a system of clearing of checks, and I want to emphasize that, which will facilitate the processing and the expedition and security of transactions of bills of exchange, of checks. The point needs to be emphasized, and I say that because I frankly, and I apologize to him, was not entirely clear in some of the submissions which were made by Senator Mark. The point needs to be emphasized that the bill before this House this evening is about clearing of checks with the use of electronic images between banks. It is not about the need for the average man or woman in the street to participate at this point in time in electronic processing of their payment system, whether by check or otherwise. I think that needs to be emphasized, and I think it is sufficiently clear if one takes the time and the trouble to read the proposed bill that is before this House. I want to emphasize as well, by way of an expression of gratitude on behalf of this government, for the time that has been taken by the Central Bank of Trinidad and Tobago and the Bankers Association of Trinidad and Tobago in producing the work that has resulted in this government being able to present this bill today before this House. And I say it by way of, first of all, acknowledging the very hard work, and secondly, addressing another point which I believe, and again, the fault may be mine, I perhaps don't understand the English language well, but I get the impression that Senator Mark was seeking to suggest that there has been significant delay on the part of this government in bringing this bill before this House. The work that has gone into being able to present this bill with the confidence with which it is presented today stems from work done between the period of 2017 to now by the Bankers Association and the Central Bank of Trinidad and Tobago. So it's not a condition of stasis. It's not as if we recognized a situation existing in 2017 and stood still. The work has been done, and it has been committed to by professionals in every sphere of the commercial industry, in banking and otherwise. The Bankers Association and the Central Bank have done considerable work. They have looked at not just the Bill of Exchange Act, which this bill is seeking to amend. They have looked at the Negotiable Instruments Dishonored Checks Act, Chapter 79, number 52, the Evidence Act, Chapter 702, the Electronic Transactions Act, Chapter 2205, And in addition to those pieces of legislation which have been examined very carefully to ensure that what we are asking this House to pass today is done with confidence and certainty, because those are requirements of proper legislative mandates. They have looked at the legislative precedents which exist in other Commonwealth countries, so that the government is today able to bring this bill before this House, knowing that the precedents from Grenada, Canada, and the United Kingdom have been examined thoroughly. And we know that this bill is patterned in particular off of the United Kingdom's Small Business Enterprise and Employment Act 2015, by which the electronic clearance system was implemented in the United Kingdom. So that the work has been ongoing. I want to emphasize that, and it's not as if there has been delay. There has not been delay. It's an ongoing process. And let me make another point, and it is a point to address legitimate concerns that have been raised by other members of this Senate, that the work in progress continues, so that electronic payment systems that will permit people to be paid by electronic transfers, while being recognized as a desirable part of our digital conversion and our digital transformation. We are not ready to do that at this stage, but it is a work in progress which this government is working on with the relevant stakeholders to ensure that in due course we will come back to this Parliament after we pass this legislation today, in order to say we have a further amendment to make to the electronic transactions that are capable of being done under the Bills of Exchange Act, and indeed under the Electronic Transactions Act, which will permit for the electronic processing of payments in manner that has been spoken today by some of our independent senators, but we are not yet ready for that today. We are at the point at which what we are asking this House to approve on a progressive and incremental basis is the system of bank-to-bank clearing of electronic images of checks, in order to modernize our system to that extent and to speed up, expedite the process. And may I address another point that has been made, and it is a useful point that has been made by Senator Welch. And that point is that he looked at Section 89A(8) and spoke to the fact that the government ought in this legislation to provide a definition of electronic image. It is a useful point, but may I reassure Senator Welch that the definition does not need to be provided for, because what is being employed in legislative drafting terminology is what is known as a neutral language. And the reason why the neutral language is simply that of the term electronic image is because electronic image, which is provided for in Section 89A(1) of the clause 5 of the bill, has to be read to mean that that image must be understood to be defined by reference to the essential features of a check. So if we cross over from Section 89A(1), which speaks of by means of an electronic image, and we go across to Section 89A(8), we see that for the purposes of this section, the essential features of a check are, and then listed from A through to G, are the essential features of the check. So when the term electronic image is used, there does not have to be a standalone definition of the term, because it is understood that the electronic image that is being captured in the banker-to-banker transaction is an image of a check which satisfies the essential features that are prescribed in Section 89A(8). So I hope that gives Senator Welch some reassurance that the term is not undefined and therefore capable of confusion. I move, Madam President, to say that the Evidence Act has also been looked at, and again, this goes back to the work that was being done by the Central Bank of Trinidad and Tobago and the Bankers Association, professional lawyers and bankers who were working on it. And it was thought at first that perhaps there needed to be amendments to different legislation. Eventually, what was decided, and we find that in Section 89A, is a simple amendment in the bill before this House to provide that an electronic image of a check presented under this section shall be admissible in evidence for all purposes for which the physical check would be admitted in evidence. That end result was the process of a very deliberate system of examination undertaken by the professionals who have supported this work that we come to this House with today. Clause 6 of the bill inserts a new section, Madam President, permitting the Minister of Finance, on the recommendation by the Central Bank, to make regulations for the purposes of the Act, and the Central Bank to issue guidelines on any matter it considers necessary. I pause for a moment to dwell on this because I was concerned in the other place, Madam Speaker, at the fact that a concern was raised by the other side, which suggested that the reliance on the use of regulations and the reliance on guidelines coming out of the Central Bank of Trinidad and Tobago and or the minister somehow or the other provide for a negative situation which provides uncertainty. The point is that one would not have thought it necessary to have to address this because we understand as legislators that when one is looking at legislation, you have to look at legislation holistically. So when we are looking at the Bills of Exchange Act, and we are looking at a rule prescribed under the Bills of Exchange Amendment Act, which is coming before this House today, we understand that we must look at other legislation. So that, for instance, there is a piece of legislation known as the Financial Institutions Act. And the Financial Institutions Act, which is law in this republic, gives a significant role to the Central Bank of Trinidad and Tobago as a regulator. It provides for oversight. The word oversight on the part of the Central Bank is defined in the Financial Institutions Act. One only has to go to the Act as a legislator to understand that. Section 5 of the Financial Institution Act goes on to provide that the central bank shall be responsible for the general administration of the Financial Institution Act, the supervision of licensees. Licensees under the Financial Institutions Act, Madam President, are banks, commercial banks. And this legislation, this amendment is about allowing banker-to-banker presentation of electronic images so that the activities of the bankers that are being provided for under this legislation fall under the regulatory oversight of the central bank as provided for in the Financial Institutions Act. And then Section 10 of the Financial Institution Act tells us the central bank may issue guidelines on any matter it considers necessary. And it goes from A through to D, and D says to regulate the market conduct of licensees. Those licensees are banks. So the simple truth which emerges for any legislator's understanding of the overarching regulatory framework of the Central Bank Act and the Financial Institutions Act, that simple truth is that commercial banks which issue checks for ordinary commercial usage are licensees within the meaning of the FIA and are subject to the control of the central bank, which may issue guidelines for their regulation as provided for by Clause 6 of the bill before you. So that for the record of this House, I wish to put on record the fact that the concern that was raised in the other place by the opposition to suggest that the use of regulation and guideline is somehow an arbitrary phrase that defies explanation or definition just can't stand in the context of the law that already exists in relation to the oversight role of the central bank. Madam Speaker, Madam President, I beg your pardon. I also touch very briefly on Senator Mark's criticism of the use of the word negative resolution, and that he wishes to bring an amendment to this House to provide for affirmative resolution. That has been dealt with already by the substantive Minister of Finance in the other House, and it has been dealt with here before again. And I just wish to underline and underscore the fact that as legislators, we understand and we know the difference between negative resolution and affirmative resolution, and to suggest that the use of the procedure, the modality of a negative resolution somehow or the other allows for arbitrariness just can't fly. It doesn't get off the ground. It doesn't get off first base, with the greatest of respect. And it reminds me, and I would touch very briefly on the point, it reminds me to remind this House that only yesterday the Privy Council produced a very significant decision in the jurisdiction, for the jurisdiction of Trinidad and Tobago. That is the decision that came out of the challenge to the public health regulations. How is that relevant to this debate? It is relevant in this respect. What the Privy Council has reminded us of in that decision yesterday is that there is significance, working practical significance, to be derived from the fact that a government is elected with a simple majority, and governments have to be permitted to function by use of their simple majorities in order to provide for effective governance in the public interest. And there is nothing illegal or wrong about a piece of legislation such as this piece of legislation come into this House by a simple majority being passed to allow for banks between themselves to permit electronic images of checks, notwithstanding the fact that the original act back in 2018 was passed by a 3/5 majority. Otherwise, the system becomes unworkable. And when one reads the Privy Council decision from yesterday in the Suraj and Maharaj matter, one appreciates how far-reaching that decision is. So I want to reassure Senator Mark, when he speaks to the need for affirmative resolution, that it is not necessary, and indeed it is going beyond what is necessary by providing for unworkable realities in the context of legislation for the public good and in the public interest. May it please this Honourable House, Madam President, I don't have very much more to say. I say that I am pleased to be able to stand here today and to contribute to this debate, and therefore, without any further ado, I say thank you very much, and I am happy to be associated with this legislation. Minister in the Ministry of Finance.